Greetings, class. Professor Chuck Slemp here. I teach one of the sections of contract law here at Regent University online, and some of you are in my class. Some of you watching this video are in one of the other sections of the class. So I just want to begin by saying congratulations. You've done an amazing job this semester. 8 weeks is a short amount of time to fit in a large amount of information. You've done a great job grasping those concepts. We've tried to squeeze them in as best as we can into 8 weeks, and I hope that you've enjoyed it. You've done very, very well. Now, you might have seen the midterm review video. The midterm covered the first few topics of the class, the first 4 weeks, and quizzes 1 and 2. Now we move on to the second half of the semester, and this video is a refresher or review for the final exam that is due this week. So as you're watching this video, I encourage you to watch the video before you take the exam, just to kind of review some of those concepts. Now the exam is just going to be covering weeks 5, 6, 7, and 8. You will have questions from quiz 3, 4, and 5 on the exam, as well as some questions that you've not seen before on any exams or any quizzes. So what I want to do now is not go over every single quiz question, but some of the ones that folks struggled on. Now I will say this, in my class at least, everybody performed really, really well on the second half of the semester quizzes. Most of the grades were stellar, and very few missing a lot of questions. So I just want to say you're getting it. You're doing a great job applying the facts to the law. Congratulations. But for those who might have struggled, or if you just want to kind of hear it explained why you got the answer right, we're going to go over some of those quiz questions. I am not going to tell you what the right answer is. That's for you to figure out, because some of these questions are going to be, like the midterm, repeated on the final. So I want to go over these. I want to kind of explain it and go through them as quickly as I possibly can. So feel free to watch if this helps you. If you're in my class, the discussion board is up for you to ask questions or make comments or review certain topics that you may not have gotten during the last 4 weeks or even this whole semester. So feel free to participate in that discussion board, and I will do my best to respond if you have a question. All right, so let's jump right into it. Week 5, we discussed the topic of enforceability. Now, you may recall that you might have an otherwise enforceable contract. You've got an offer, you've got an acceptance, you've got a consideration, but yet something is wrong with the contract to make it unenforceable. Somebody did something they shouldn't. So in this week, we covered undue influence, capacity, duress, misrepresentation, and unconscionability. Now there's several questions here taken directly from our lectures that I ask, what is fraud in the factum, right? Or what is fraud in the inducement? I'm not going to go over those questions. Those are pretty self-explanatory. What I will go over are some of the factual scenarios where you had to apply facts to the law and try to pick one of the correct answers. In no particular order, my computer puts these up here, so I'm going to go through these as best I can, again, in no particular order. All right, so the first one we'll talk about is the one in which the seller is buying buyer's home. And after they've got an enforceable contract and they've got the closing date, seller shortly thereafter starts moving out the refrigerator, the stove, the light fixtures, all of those things. And buyer is told about it. Portions are also damaged. So when buyer told seller about these facts, seller then refuses to close the sale unless buyer agrees to modify the contract by replacing some things or missing or damaged things. All right, so now the question is this. Seller knew that the buyer has no alternatives. He's stuck. He has to move He has no place to move, and has to have his house sold. So he had to give up possession on the date set. So there's no available rentals nearby, and after the sale's closed, buyer sues seller seeking to set aside the release. Will the buyer be successful? Well, you've got two responses of yes and two responses of no. This one basically asks you, is the seller making a improper threat to not perform? I'm not going to tell you the answer, but I will direct you to the Restatement of Contracts, section 175.1, that talks about duress by threat, making a contract voidable by the victim if a party's manifestation of assent is induced by an improper threat by the other party that leaves the victim no reasonable alternative. The answer here includes both required elements, and the improper threat coupled with overcoming the will of the party. I will say that this problem is modeled after a case from Kaplan versus Keith, a 1978 case. If you're looking for the site on that, if you want to look it up and read the case, it's 377 Northeast 2nd, 275, 1978. All right, let's move forward to the next question. And that one has to do with the landlord owning and managing an apartment building. Unfortunately, the landlord frequently suffered from hallucinations. Oh boy. To help control these hallucinations, he took medication. The hallucinations were not known to anybody outside. He kept it a secret. Nobody outside of his immediate family knew about it. So the landlord was symptomatic, so to speak, and he was sympathetic to anybody who struggled financially. It often reduced people's rent by $100 per month when they provided documentation that their income fell below a certain financial spot. Nice guy, right? In exchange, if they would do gardening services or something, cleaning for the building, that kind of thing. Because the landlord offered these lower rent tenants this discount, he received some tax credits at the end of the year that made up the difference in his loss of income. As he aged, his hallucinations could no longer be managed by medicine. So, a brother took over the management of the property, and brother decided to charge all the tenants the same amount of rent. Maybe he wasn't as nice a guy as his brother. To reflect the fair rental value. Brother asserted that those who'd received reduced rent had taken advantage of the landlord's mental incapacity. Now, the tenant is a renter. He was one of landlord's tenants whom landlord agreed to have this reduced rent amount. This tenant refused to pay the brother's new proposed rent. So brother brought a claim against him for the rental value of the apartment, fair market value. Brother argued that the lease agreement was voidable because of his brother's mental incapacity. Will this brother, the stingy guy, Scrooge, will his claim succeed? In order to answer this question, again, like others, you've got two yes and reason and two no and reason answers. To answer this one, you need to go to the Restatement of Contracts, section 15.2. Where the contract is made on fair terms and the other party is without knowledge of the mental illness or defect, the power of avoidance terminates to the extent that the contract has been so performed in whole or in part that the circumstances have so changed that avoidance would be unjust. It's all about fairness and justice, right? The lease agreement here, does it appear to have been made under fair terms? A reasonable person? I guess so, right? That the deduction in rent, was it reasonable? And did the landlord take active steps to determine if the tenant was qualified or not by asking for documentation? And did landlord's condition, was it known by the tenant? I don't think so. Looking at these factors, we can then conclude whether or not we think the contract is voidable. This problem is modeled after a case, Hernandez versus Banks, 65A 3D 59. And that's a 2013 case. Pretty interesting. All right, let's jump forward to another example about the same lines, and this one is mistake. This one's about mistake. It's the California case, right, in which the state of California published a newspaper advertising the sale of some various items. The advertisement also included the statement, "Please read the warnings available where the property is stored in a California warehouse." The warnings document described the advertisement on the best available information, but the property had been in storage for years, so that not all the information was certain. So there was a disclaimer here, right? 9 a.m. On December 2nd, the day after the publication, the shipping supply company showed up at the warehouse and made an offer to buy the nets, the items here, for $30,000. The seller accepted the offer, and nobody inspected them to see what kind of condition were they in, the condition that the advertiser expected, all those sorts of things. Then later, about a month later, or the 18 days later, the Portsmouth arrived at the warehouse to pick up the nets, and at the time, Portsmouth discovered that the nets were not made of the type of rope that was promised. They immediately objected, pointed out that these were different types that sell for 50% more and twice as durable. And so Plymouth had already resold the nets to one of its shipping customers, promised that they were what they thought it was. So, all right, here's the bottom line question. If Portsmouth sued to rescind the contract based on a mistake, would they succeed? And so, again, you've got two no's and two yeses, and this goes to mutual mistake. This question to obtain relief based upon mutual mistake of the parties. The party seeking to get out of the contract must show that the mistake was made as to the basic assumption on which the contract was made, has a material effect on the agreed exchange of promises. That language that I just quoted here, it's a little wonky, right? It comes from the Restatement Second of Contracts, section 152.1. Look at that. And also under Restatement Second of Contracts, section 154, it notes that a party bears the risk of mistake if the risk is allocated to him by the parties, or if he's aware at the time of the contract that he has limited knowledge with respect to the facts or what it is you're selling. So the question here, did Portsmouth have knowledge that it failed to inspect the property properly, and therefore failed to learn whatever it would have in order to being able to say, no, it's a mutual mistake? Basically, the question here you've got to determine, based upon your reading of the restatement, is did Portsmouth assume the risk? All right, let's move forward. We got a couple more here with the quiz from week 5, quiz 3, and then we'll jump into quizzes 4 and 5 from weeks 6 and 7. It's a little confusing, sorry about that. All right, so let's do the one about the 88-year-old woman in the wheelchair suffering from Alzheimer's. She relied on her granddaughter for daily support. One day, the granddaughter told the grandmother, the lady, and we call her seller here in the problem, to sell her classic Cadillac to the granddaughter. Granddaughter needed a car to use to earn a living as an Uber driver. So the fair market value of the car was $80,000. Woo! It's a steep Cadillac. But granddaughter had advertised the car to sell to the granddaughter. Okay, so advised seller to sell the car to granddaughter for $7,500, a steep discount. Seller trusted granddaughter. She trusted her granddaughter, right? And she did indeed sell the car for a deeply discounted $7,500. Now, later, the seller, grandmother, wishes to undo it. Can she rescind the contract? Yes or no, and then why? So you've got a couple different questions here. Basically, this question focuses on the principle of undue influence and undue persuasion. So, as we know from the definitions, undue influence is the unfair persuasion of a party for whom domination of the other party is made through virtue of some kind of special relationship between them, justified in assuming that the person will act in a manner that's consistent with her welfare. Here, the grandmother assumed that her granddaughter would be fair and would act in a way that's good for the grandmother. And so she was in a position of trust and authority, a fiduciary, which is a legal funny term here that we use to describe that relationship. I want you to go to Restatement Second of Contracts, Section 177, Sections 1 and 2, subsections 1 and 2, for the quote about what it is that undue influence, the definition of undue influence. And so when it comes to determining unfair persuasion, when you're looking at this, naturally we all guess that this is not right, that's not fair. But why is it not fair? Is it because the contract was void because of duress, or was it voidable because of undue influence? And that's the question you're going to have to sort out based upon your reading of the restatement as I provided it to you there. Let's jump to the last one here for this quiz, and that's the patient and pharmacy. We've got a contract between the two. The pharmacy agreed to supply the patient's prescription drugs for the month of March and April. Well, the patient chose the pharmacy because it only charged $100 for his monthly prescriptions. The price was a good deal because prescriptions helped him a lot with his recently diagnosed and life-threatening disease. The patient had been told to expect the prescriptions that they would normally be more than $500 a month. So the patient paid the $100 on March 1st and was expecting their delivery on the 15th. When it came time for the pharmacy to deliver the prescriptions, though, the pharmacist called and said, "We're not going to do it because unless you pay $150 more a month. We're not running a charity here. You're getting a good deal at $250 because it's going to cost you more like $500, and $100 is just too little." The patient didn't have time to find another pharmacy. After he received his medications from both March and April and paid for them at the higher price, the patient decided to bring a claim against the pharmacy. The patient then claimed that the pharmacy and the threats amounted to duress and said that the modification, the extra $250 or $150, was voidable. Will that patient's claim be successful? All right, so the question here is based upon modification. So for this modification to be voidable, there's got to be some kind of improper threat and no reasonable alternative, right? If a party's manifestation of assent is induced by improper threat by the other party that leaves them no reasonable alternative, then the contract is voidable by the victim. See the Restatement Second of Contracts 175.1. All right, so this was clearly a threat that may be expressed in words or inferred by the conduct, right? However, a threat, even if it's improper, does not amount to duress if the victim has a reasonable alternative to succumbing and fails to take advantage of it. All right, so you got to mitigate. In the case of a threatened denial of needed goods or services, and this is directly from the comments, comment B, in the denial of needed goods or services, the availability of the market of a similar good or service may afford a reasonable means of avoiding that particular threat. So even if the pharmacy threatened to withhold the patient's medications unless he paid more, the patient did not seek a reasonable alternative. The facts state that prescriptions here were readily available for $500, so they weren't unique in that sense. And the only pharmacy, this place was not the only pharmacy that carried them. Thus, did patient do all that they should have done in order to avoid the situation, the modification of the contract? You might not agree with this, but that's the law moving forward. So that's the answer we were looking for on that particular question, without telling you the answer. All right, we're about 20 minutes into the video. We're going to go just a little bit more here and keep going through these questions. Let's go into quiz number 4, which was during week 6. Now, week 6, as we were going through the class, we were looking at what the terms of a contract meant, how the contract terms were interpreted, what we do, what evidence we look at to govern a dispute between the parties when they say, and that's not exactly what I agreed to, and how is the contract interpreted. That's what we were focused on. There's a question in quiz 4 about what is the parallel evidence, what's the plain meaning rule, explain those things. Those are self-explanatory. Again, what I'm going to do is I'm going to try to go through the 4 or so questions that were based upon a factual scenario and try to give you some direction there. If you watched the video or read the material for that particular week, you would have been able to answer the bulk of those questions. All right. Let's look at one of those questions in no particular order. And this one was about teachers signing a written integrated agreement to exchange lesson plans. And this agreement described itself as a quote-unquote completely integrated and included all the terms that one might expect to be in such an agreement. As the teachers were signing this agreement, they orally agreed to check with each other and with other students, and if both groups of students hated the idea, they would not go forward with the deal. Would the evidence of that oral agreement that they talked about while they were signing it be admissible? That's the question. And for this, you need to look at Restatement Second of Contracts, Section 217, which says, where the parties to a written agreement agree orally that performance of the agreement is subject to occurrence of a stated condition, it's a condition, the agreement is not integrated, even if it says it is, with respect to that oral condition. Here, the oral condition, or the oral agreement was a condition, and evident, not certain to occur, but which must occur before performance is due, and is therefore within the context of this rule. Although the parties have a written, quote-unquote, integrated agreement, Section 217 of the Restatement requires a conclusion that the agreement is not fully integrated or completely integrated as to the term of that condition. So look at those sections and then reanalyze those particular answers here. Let's look at this one regarding the seller and buyer having a written term of contract for 53 acres of land. That buyer is going to buy for $4,000 for the land plus the total cost of preparing the land for sale. So the writing is complete and final and an exclusive statement of the parties. Buyer and seller are both farmers. Actually, by the way, 53 acres of land for $4,000. Woo, what a deal. Must have had a lot of upkeep. Buyer and seller are both farmers. They entered into similar transactions with each other before, and therefore they're familiar with the costs of preparing the land as was required here after it's been used, and as seller's property had been used for harvesting vegetables. Now here, the seller was ready to sign over the 53 acres to the buyer, but the buyer handed a check for $6,000. Seller responded, the check for $7,000 should be for $7,000. We both have been through transactions like this before, and the cost of preparing the land, similar, should always be $3,000. Buyer refused to pay that extra $1,000. So he sued, the seller sued for breach of contract and sought to introduce evidence of their prior negotiations and transactions. Will a court be able to conclude that this parallel evidence the parallel evidence rule bars the introduction of that evidence from their prior negotiations? You got a couple yeses, you got a couple no's. Let's look at Restatement Second of Contracts, Section 214C. That says, agreements and negotiations prior to or contemporaneous with the adoption of a writing are admissible in evidence to establish the meaning of the writing, whether or not integrated. If a contract is ambiguous, evidence of course of dealing between the parties is admissible to help resolve that ambiguity. Now, because the quote-unquote total costs here is ambiguous, you should determine whether it's appropriate for a court to look at the parties' past dealings in order to interpret the contract. So if they can, well then the answer would be no. If they can't, for whatever reason, then the answer would be yes, right? Because the answer is not whether he can introduce this, but whether the parallel evidence keeps him from introducing this. I think a couple folks got maybe those terms confused because of the wording of that question. It's not a trick, it's just you need to pay attention to how things are worded in the law because the wording is very important. It can make the difference between liability or not. Let's look at the handyman, $50 getting from an owner that he owed him, all right? Some kind of prior transaction. Owner of property owed this handyman $50. They both had orally agreed that the handyman would clean the rain gutters at a homeowner's house, and the owner would pay $1,000. No, excuse me, $100. Woo, that was steep. $1,000 versus $100. The payment would cover both the price of the gutter cleaning and also $50 that the buyer owed. A day later, the parties signed a written agreement. The $50 debt was not mentioned in that written agreement, which was 1 page in length. It was just a short document and did not contain an integration clause saying that it was fully integrated and only what they agreed upon. Well, the handyman cleaned out the gutters and the owner paid him $100. A week later, handyman called the owner and said, "I want my $50 that you owe me." And owner said, "We agreed. You would get the $50 plus what I owed you for the rain gutter, and it would be a total of $100. Handyman says, "Well, that's not what's in the written agreement between us." Well, handyman sought to bring a claim against owner for the extra $50, and buyer wanted to introduce evidence of their oral agreement that of the $100, covering everything. Will this evidence be admitted over the parallel evidence rule objection of the handyman? Well, for this, we need to look at Restatement Second of Contracts 216, 1 and 2, subsection B. In that section, evidence of a consistent additional term is admissible to supplement an integrated agreement unless a court finds that the agreement was completely integrated. An agreement is not completely integrated if the writing omits a consistent additional agreed upon term, which is a term that is used in the circumstances where it might be omitted from the writing. So essentially, in a situation where we're dealing with the term of the $50 credit towards the buyer's credit, it can can it be seen as naturally omitted from the contract? Because it's usually a service contract doesn't include something like that, prior transactions. I think, yeah, probably. Therefore, a court should probably be able to look at the oral agreement as to the supplement in the writing. Now, the oral agreement, if that's the way you interpret this, the oral agreement is going to be admissible if the court determines. So remember, there's a if here in one of these answers. So that's a sign that, you know, this is going to be up to a court. You might not necessarily agree with whether this evidence should be admitted or not, but if a court determines that, then that's going to be consistent with it and going to be admissible. So there's your answer on that one. All right, so let's go to the last one here. All right, so landlord which owns several restaurant properties leased the restaurant premises to the tenant, the guy running the restaurant chain. He actually owns a bunch of chain restaurants. The lease included, among other things, these terms that are spelled out in the question. Number 6, landlord will pay for electricity. Number 11, tenant will pay for gas or fuel used for storing or preparing food. Number 12, the parties note that the tenant is contemplating installing an electric sub-zero refrigerator that will require substantial electricity. If the tenant does install that refrigerator, an expensive type of refrigerator, right, the tenant shall install a special meter and then pay for the extra electricity used by the new refrigerator. The dictionary defines fuel as material, such as coal, oil, and gas, burned to produce heat. In the restaurant industry, electricity is the uniform type of fuel for this particular contract. And in operating the restaurant, tenant used both gas and electric stoves already placed in the restaurant. When the landlord refused to pay for the electricity used by the tenant in his stoves, the tenant sued for breach of contract. Will the tenant win is the question here. So this basic question requires you to interpret the word fuel, right? The word fuel has a trade usage that includes electricity, and both parties are in that trade. So the better argument here, if you're looking at it, is that paragraph 12 of their contract, which you've got a copy here, communicates that the parties are not following the trade usage, right? So even though most restaurants uniformly use electricity, their contract under paragraph 12 says that because they're going to agree to track it a different way, if the tenant has agreed that it's going to be a different way, you're going to use and look at restatement second of contract section 202 and the illustration there, illustration number 10 there. All right, so that is all the questions that we're going to review from quiz number 4 in week 6. Let's jump finally to quiz number 5, all right, in week 7. Now, that's last week. You should have just finished it. Now, some of you might not yet be done with quiz 7, or excuse me, this particular quiz, quiz 5, during week 7. And week 7, as you know, is the week in which we begin to discuss contract obligations and the parties' performance. So if you have not finished your quiz for quiz 5 in week 7, when this video is uploaded, stop watching right now, take the quiz, and then after you finish it, in preparation for the final exam, you can come back and watch the test. You're on your honor to do this. So I'm not going to, I don't want somebody to get unfair advantage by completing the quiz. And in fact, in my class, I'm not going to post this video until after the quiz is done. But I'm just throwing that out there in case the other classes get the video before the quiz is due and finished. So please do the right thing here. This week, week 7, we just got finished talking about conditions, conditional promise, right? Or something else happening. And what happens when somebody breaches? Is it based upon some kind of excuse? And are there conditions that can be worked into a contract that might impact the party's performance of their duties? Now, this week, we also, again, had some questions taken directly from the book and questions like definitions taken from the lectures. I'm not going to go over those. If you watched the video, if you took the exam, you should know those. Let's talk about, however, some of the questions here in these multiple choice factual scenarios like we have been. And so I'm going to actually stop this recording, and I'm going to do a second recording that will have those questions being answered or being discussed in the second video. And the reason I'm breaking that up is we're already at 36 minutes for this video, and the video takes a long time to upload if it's any more than 30 minutes. So I'm going to stop the video and then re-record or record a new one for the rest of this section. Thanks so much for watching.